Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today may be the day I earn your subscription. For today's case, we're dealing with the appeal from Dylann Roof, who committed a mass murder in Charleston. This is the United States of America versus Dylann Roof. In this appeal, there are a whole lot of issues that are being decided. Long story short, Dylann Roof didn't win. His death penalty conviction still stands. But there's still some good legal analysis. Now, the entire appeal is 150 pages long, but we're only going to cover parts of it. We're going to cover the parts dealing with him representing himself at sentencing, because that's fun. And we'll also deal with the part dealing with whether or not the federal statute itself is constitutional, which is also fun. So there's a whole bunch of other legal issues that we'll skip over, but we'll discuss those parts. So let's get started with this. Now, there is one note here that's very interesting on a technical level. This is before the United States Court of Appeals before the Fourth Circuit, but the entire Court of Appeals for the Fourth Circuit recused themselves. Incidentally, the reason it appears to have happened is one of the members of the court was involved in the prosecution of Dylann. Now, that certainly makes him not available to be on the Court of Appeals, but it looks like everyone else decided to recuse themselves out of some sort of abundance of caution. So this is before the Court of Appeals, before the Fourth Circuit. It's just that none of the members deciding this are members of the Fourth Circuit. So this case is being decided by Judge Benton from the Eighth Circuit, Judge Jordan of the Third Circuit, and Judge Gilman of the Sixth Circuit. So that's the thing that's happening. That's just interesting. So let's press on. Just to briefly recap the crime, in case some of you might have forgotten, on June the 17th of 2015, 12 parishioners and church leaders of Mother and Emmanuel, all of whom were African Americans, gathered in the fellowship hall for their weekly Bible study. At around 8:16 p.m., Dylann Roof entered the fellowship hall carrying a small bag that concealed a handgun with 8 magazines loaded with 11 bullets each. For the next 45 minutes, Dylann Roof worshiped with parishioners. They stood and shut their eyes for closing prayer. Dylann Roof then took out his firearm and started shooting. Parishioners dove under tables to hide. Dylann Roof continued shooting, reloading multiple times. After firing approximately 74 rounds, Dylann Roof reached to one of the parishioners who was praying aloud. He told her to shut up and asked her if he had shot her yet. She said no. Dylann Roof responded with, "I'm going to leave you here to tell the story." Dylann then left the church at around 9:06 p.m. When the police arrived, 7 of the 12 parishioners were dead, 2 died shortly thereafter. So yeah, this was the famous shooting in Charleston, South Carolina at Mother Emmanuel Church. This guy was welcomed in with open arms. For 45 minutes, they were praying and stuff, and then he just decided to hurt a whole bunch of them. With a brief background of the Roof incident, we now have to discuss the 2 issues, at least, that I want to focus on. So the first issue I'd like to focus on is his self-represents during the sentencing phase. Dylann over here represented himself, and he'd like to complain about that now. We're going to discuss the standards that comes to self-representation and how the law applies there. So let's read that. As discussed above, after learning that his lawyers plan to present evidence of mental illness, which, is probably a decent legal strategy, Dylann sent a letter to the prosecution the night before jury selection, accusing his lawyers of using scare tactics, threats, manipulation, and outright lies to push a trial strategy. He said, "What are my lawyers planning to say in my defense is a lie and will be said without my consent or permission." Shortly before trial, defense counsel requested an ex parte hearing to discuss Roof's letter. Shortly before trial, defense counsel requested an ex parte hearing to discuss Roof's letter. They contended that he controls only a few major decisions in the case. Counsel controls the rest. That's true, including the decision of whether to present mental health evidence. The issue Roof controls, counsel wrote, includes whether to plead guilty, waive a jury, testify in his or her own behalf, or take appeal, but not what witnesses should be called or what evidence should be introduced. So this is completely correct as a matter of law. This is not disputable. There are some decisions that are for the client and some decisions that are for the lawyer. The major distinction between the two is the client gets to set the goal, the lawyer gets to set the means to get there. So the client says, "I want this result." The lawyer says, "I'm going to do this to get there." The client can't then say, "No, I don't want you to do that," or "I want you to do this," or "I want you to do this other thing." No, that's not how that works. You as the client get to select what lawyers you want, and you get to select what goals you want. You don't get to control what the lawyer does in furtherance of those goals. If you want something else, find a different lawyer. So in a criminal case, there are certain decisions that are reserved for the defendant. Whether or not to plead guilty, right? That's what I want. Whether or not to waive a jury, deemed to be fundamental, testify on their own behalf, that's a Fifth Amendment protection, or take appeal. That's also, what do I want? Do I want to appeal? But not, what witnesses do I want? Call this guy, don't call this guy. Ask that question, don't ask that question. No. Or what evidence should be introduced? Present this exhibit, don't present that exhibit. No, that's not how any of that works. The client sets the goal, the lawyer sets the means. That is the rule. The district court postponed jury selection and held an ex parte hearing to question Roof about the letter. So this is being held ex parte, but it's for the purpose of determining what the client wants. Only defense counsel is there in this hearing, which is fair enough because it's going to, what do you want? So the prosecution can't be there for that, so it's ex parte. The court informed Roof that his lawyers have the right to offer mitigating evidence they think is best because it's a strategic decision. That is 100% correct. That's the lawyer's call. And further advised him, if no mitigation evidence is offered, there's a high degree of probability that there's a death penalty. Like the judge, there seems to be a lot of evidence here. If it were me, I'd probably want the mitigation evidence offered because if you have any hope at all, focusing on just one of these issues, Dylan Roof responded, I get that, but the problem is the price if people think I'm autistic. Then it's not worth it. The court probed him on this point at length, asking, for example, if in fact your autism experts are right, wouldn't you want a jury to have that information and make the best decision? To which Roof responded emphatically, no. The court then asked, and Roof confirmed, that he'd rather die than be labeled autistic. Later, he elaborated that if people think I have autism, it discredits the reasons why I did the crime. The court responded there are many people with autism who are high-functioning, adjusted people. It went on to repeat this question in numerous forms, and Roof continuously affirmed that, in his view, it is better to die than be considered autistic or mentally ill. And because evidence of mental health was what his lawyers wanted to present as his primary mitigating defense, he wanted to present no such defense. So the lawyers, looking at the evidence against him, which, is pretty good. So we've got, first of all, you specifically left alive a witness. You asked this witness, have you been shot? To which they say no. And you specifically said to this witness, I'm leaving you alive so you can tell the story. So this witness, there's that. There's the ballistic evidence. There's the camera evidence, and so forth and so on, and so forth and so on. Not looking really great for you on the issue of whether you did it or not. Looking super great. Mitigating evidence would be helpful. Now, we may be able to plead insanity, but that doesn't really work very well. But we don't necessarily have to plead insanity. We can say that we were mentally impaired without going to insanity. So legal insanity is the far end of the spectrum, which would prevent liability, right? That's the far end of the spectrum. But you don't need to get to the far end to argue the point. If you have any sort of mental impairment at all, even if it doesn't ultimately impact your guilt phase, it can impact the sentencing phase because what's admissible in sentencing is a much wider range of material, especially when it comes to mitigating. The defense lawyers think to themselves, well, I don't have a whole lot to work with because he specifically left alive a witness to tell the story who has now told the story, and the ballistics and the purchase of the gun records and the other statements and so forth and so on, not looking real great. What I'd like here is to offer evidence that my client is mentally impaired in some way, which might include him being autistic. This seems pretty reasonable. And Dylan over here objects to this evidence being offered. And the court points out quite properly that this is not Dylan's decision. He can choose whether or not to plead guilty, including by reason of mental defect. He can make that decision. But whether it's offered as evidence in mitigation, not so much. And it reminds me a little bit of a holding from the U.S. Supreme Court when it came to the power to plead not guilty. Because there was a case in which the defense lawyer, which he pled not guilty, and the defense lawyer said he's guilty multiple times without changing the plea, and he was convicted, and that was thrown out. And in that decision, the U.S. Supreme Court, I think it was Justice Scalia writing, although I could be mistaken, said something like, the power to plead not guilty is a fundamental power. Because if you plead guilty, you're saying I did it. You're saying I did it. And even if you're 100% sure that you'll be convicted and sentenced to death, even if you can know that for an absolute certainty, someone might make the choice, and it might be a completely reasonable choice to say, you know what, I'm not willing to say I did it because I didn't do it. I know you have the evidence. I know you've got it. I know you can convict me and you can get the death penalty. I understand you're offering me a plea with my life, but I'm not going to do it. I'm not going to make the admission because I didn't do it. Better for me to die than for me to admit that I did it because I didn't do it. And the Supreme Court wrote in that decision, and I think quite correctly, that's a decision someone can make. It's more important for me to say I'm innocent than to convict myself, even if the punishment is lesser. That's a trade-off someone can make. It's better to hold on to my integrity, to hold on to my honor, than to make that decision. Makes logical sense. So Dylann Roof's decision here is understandable, at least in that light. Better for me it reminds me of the line from the movie where the guy is sentenced to death, and he's saying, and one of the guys who's also sentenced to death with him, he says, you need to stand tall when you're being executed. And the line is, you fool, as if it makes any difference how a man falls. And the man says in response, when the only thing left is the fall, it matters a great deal. I'm like, okay, I can respect that. I can respect that decision. Dylann Roof over here, I don't want to say I'm autistic. I don't want to say I'm mentally impaired because it would ruin the purity of my actions. Okay, there's something honorable in there somewhere, I guess. He wants to take full accountability for everything he did and all of his noxious motives behind it. There's something in there somewhere. And so his lawyers want to save his ass, and he's not very interested in that. The court says he doesn't get to make that choice, which leads us to the next step. How can I get there if the lawyers won't do it? That's right, I represent myself. So yeah, that's the next logical step in this chain. So following this exchange, defense counsel stated although they had considered this perspective, they nonetheless determined that presenting evidence for mental health issues, psychosis, depression, autism, and anxiety was in Roof's best interests. The lawyers are correct. From an objective standpoint, the district court described the standoff as having no solution because any competent attorney would insist on asserting this mental health, particularly because I don't have anything else to work with, and Roof is going to oppose any effort to present what I think a competent lawyer should do. The court then reiterated what it previously told Roof. A lawyer is not free to say simply, okay, I won't present that evidence because you don't want me to, because that's not the defendant's decision to make. Under the law, that's correct. That is not the decision of the defendant to make. You don't get to control what evidence I present, what witnesses I call, what questions I ask. You can sit there quietly while I do my job. Later, the court memorialized this decision in a written order, stating, the decision concerning what evidence should be introduced in a capital sentencing, or for that matter, any criminal proceeding, is best left in the hands of the trial counsel, and reasonable tactical decisions by trial counsel in this regard are binding on the defendant. That's the correct statement of the law. Dylann over here, displeased with the law, decides to discharge his lawyers and proceed pro se, which, is an option that is available to him, particularly when no reasonable attorney wouldn't do this. If no reasonable attorney would do it, only thing left is for me to do it myself. The court responded by explaining the responsibilities, confirming he understood that he'd need to make as-needed motions or objections, ask questions, make arguments, and be performing in the courtroom throughout the trial. It also advised him that standby counsel will be available to assist him if he desired that assistance, so the court granted the motion and appointed standby counsel. So standby counsel is very typical, especially in a death penalty case, as you might imagine. It's a lawyer who's there, his job to advise you. He's not a lawyer for you. Let's rephrase that. He's a lawyer there to advise you. That's what makes it advisory. He's an advisory counsel. So his job is not to ask questions or make objections or any of that shit, but he's there to give you suggestions. Dylann Roof represented himself during voir dire, so this is the process of selecting the jury. His standby counsel filed 3 motions, which the court refused because he's not the defendant. Standby counsel informed Roof that he had read a particular case and is comforted by that at least seems to allow the court to permit him to ask us to do things he doesn't know how to do. The court responded with the following. So there's some case that says the court can help him along the way. The court responded with the following. I considered what he's been doing to be actively participating in voir dire process. He has made motions, some of which have been granted and some of what not. And he's received assistance of his counsel. It further explained that his lawyers acting as co-counsel would be very confusing to the jury, and kind of a play on the system where Ruth, for example, could avoid cross-examination but could then speak. When standby counsel asked whether Ruth could repeat that they asked a question or raise an objection, the court declined, saying Ruth makes the decision whether he wants to ask follow-up questions and which ones, not you. You speak to him. He's an intelligent person. We're using this term in a technical sense, by the way. He can make that decision. It's his decision because he's elected to self-represent. This is completely correct from the court. This is the role of the standby counsel. Yep, it's his decision to make. And when standby counsel argued the court's rulings were too strict, particularly dealing with voir dire, the court stood by it by saying it's just the proper role of standby. That is, in fact, the role of standby. Your role is not to ask questions or make objections or anything. Your role is strictly to provide advice to the defendant, period. The defendant isn't in control of this party, so yeah. At this point, the court further explained that standby counsel could suggest questions, but he would have to ask them. However, Ruth moved to allow his standby counsel to represent him during guilt phase, but return to self-representation for penalty phase. So he says, okay, I want my lawyer to represent me during guilt, but not during penalty. Okay, at the pre-trial conference, the district court explained to Ruth what this would mean. The court stated defense counsel would control all strategic decisions in the guilt phase, including what witnesses to call, what questions to ask, and what evidence should be introduced in the guilt phase. This is the guilt phase, not the punishment phase. So this is liability phase. This is decisions for the attorney. Ruth would retain control only over what plea to error, whether to accept a plea, and whether to testify, which is his call. And he'd have to waive his right of self-representation for the entirety of the guilt phase. Fair enough. Ruth's standby counsel expressed support for the motion. So he says, can you be my attorney only for the guilt phase but not punishment? Ruth's attorneys isn't into this. So prosecution doesn't take a position because why do they care? The court granted the motion allowing Ruth to retain right to self-representation during the penalty phase. So it's your call. It's your call. You want to represent yourself now and have your attorney represent you then. That's fine. You can also represent yourself at that phase too. That's also fine. And as he planned, Ruth proceeded again to represent himself during penalty phase and did not present any mental health evaluations. In a capital case, the case is strictly bifurcated between the underlying penalty and the sentencing phase. In different cases, this can be less bifurcated, but in a capital case, they're strictly bifurcated because of the Supreme Court. So you have the guilt phase or the liability phase, and then you have the penalty phase. These are two different phases, and the rules are very clear. You can have a lawyer for one phase, not the other. So you can represent yourself for the first phase, have a lawyer for the second phase. You can have the lawyer represent your first phase. You can represent the second phase. You can represent yourself the whole way, have the lawyer represent yourself the whole way. They're bifurcated. So yeah, you can do that. So you want to represent yourself during the penalty phase? Okay, that's an option. Zafal asked, shouldn't the court have had a ruling on Sandy? Yes, they did, and that was part of the appeal. It's just not a part we covered. So yes, there was a ruling on Sandy, and that was also appealed. It's just not a part I found interesting. So yeah, that definitely happened. Ruth first argues, although he preferred not to waive counsel, he went forward with the waiver for one reason alone, to prevent presentation of mental health mitigation. Yeah, that's right. He asserts this decision to represent himself was not made knowingly. He instead made it under misinformation from the district court because the court told him if he employed counsel, then counsel would have exclusive authority over presentation of penalty phase evidence, which seems belied by what the district court actually just told you just now, but okay. The Sixth Amendment provides that in all criminal prosecutions, the accused shall have the right to have assistance of counsel for defense. That includes the right to waive counsel and to represent oneself, but the decision to relinquish that must be made knowingly and intelligently. Dylan Ruth claims the district court misadvised him that he could not choose a primary objective of the defense that may not be labeled as mentally ill or autistic. Defense counsel wished to present evidence that conflicted with this aversion to suggestion of diminished mental capacity. Ruth contends counsel should have been forced to conform to his objective, and he should have advised that he could have constrained counsel in that way. Yeah, no, I'm sorry, Dylan. That's just not the law. The attorney cannot be forced along those lines. The attorney can be forced in some of them. The decision to plead guilty, the decision whether or not to testify, the decision whether or not to accept a plea, the decision whether or not to appeal. These things, the decision whether or not to waive a jury trial, these things are within the defendant's control, no matter how much it irritates the attorney. But yeah, they should have been forced to conform. No, that's not how that works. No. We do not subscribe to Roy's. When one chooses to have his lawyer manage and present the case, he cedes the power to make binding decisions of trial strategy in many areas. The presentation of mental health mitigation is, in our view, a classic tactical decision left to counsel, even where the client disagrees. The law does not subvert this long-established distinction between objective and tactics. That's the distinction. Objective, tactics. Clients get to control the objective. Lawyer controls strategy and tactics, which underlines our decisions. Roof's interpretation of the case law is flawed because it would leave little remaining in the tactics category by allowing defendants to define their objectives too specifically. Yeah, you can't. The objective is, I want to be not guilty. That's the objective in this scenario. The objective is, I want to be not guilty and also not present this evidence. No, that's not the objective in this scenario. Guilty or not guilty, that's the objective. In other words, the government rightly contends Roof's position would allow defendant to exercise significant control over what's the most important aspect, such as the presentation of particular evidence, whether to speak to a specific witness, or whether to lodge an objection, so long as he declares a particular strategy and tactic to be of high priority and labels an objective. That cannot be. That interferes too much with the role of the lawyer and the professional obligations of the lawyer. As a lawyer, Roof next argues the district court should have denied his motion to dismiss counsel and proceed pro se because he did not have a Sixth Amendment to represent himself during the penalty phase. This is a strange argument. They should have denied the right to proceed pro se in the penalty phase. Okay, no. Again, we disagree. I would think so. He's entitled to represent himself in the penalty phase. Yep. Roof contends unpersuasively that the penalty phase of the trial is similar to an appeal. No, it's not. It's a bifurcated trial. It's separating liability from remedy. Did you do it? What should we do about it? So it's separating liability or guilt from penalty or remedy. It's a bifurcation. It's not an appeal. He makes several arguments, including the right to a separate penalty phase at a capital trial has little historical precedent. That's true. It was established by the Supreme Court relatively recently in modern history. Much like appeals of right, there's no right to self-representation at the penalty phase because it can be inferred from the text of the Sixth Amendment. Really? And because defendant at sentencing is no longer the accused, because at that point he's been convicted. Lastly, he contends that the unique, individualized, and reasoned moral judgment that occurs during sentencing is consistent with the reasons courts have declined to impose other Sixth Amendment rights at capital sentencing. His argument ignores precedents that suggest there is a Sixth Amendment right to effectiveness of counsel at the penalty phase of capital cases. You're entitled to a lawyer during that phase, yes. The Supreme Court has also previously extended Sixth Amendment to counsel to a separate deferred sentencing proceeding followed probation. The right to self-representation does not have a long history of being applied to sentencing proceedings. Is not enough reason to exclude it from the holdings. Respect for autonomy of defendants should continue through all phases of the trial. It is still the trial, that's true. There's ample reason to apply the same rights as are granted at the guilt phase of trial, because penalty decisions were, as a matter of historical practice, made at essentially the same time as guilt. Or whether or not they're part of the same time, they're part of the same proceeding. No matter how attenuated it may be, it's still part of the same proceeding. The autonomy-based right to self-representation remains equally valid at the penalty phase. We hold the district court did not err by allowing Roof to represent himself at the penalty phase of his trial. We've discussed the portion of whether Dylan Roof can represent himself at the penalty phase. The answer is very unsurprisingly yes. He can. He did it for a very particular reason. He didn't want evidence that he was mentally impaired in any way to come in because he didn't want the purity of why he did what he did to be impacted by any mental health issues. Okay, fine, Dylan. We here at Uncivil Law are more than happy to conclude that you are fully sane and fully competent and not so much with the mental impairment as just evil. We are perfectly happy with that conclusion over here. So, fine, and you got to represent yourself and you got exactly what you wanted, so yay. Now, of course, there's also a question of whether or not Congress can pass this law or not. So this is issue number 17 in the appeal, incidentally. We're skipping around. So we're going to discuss whether or not this law Congress passed is constitutional. In 2009, Congress enacted the Matthew Shepard and James Boyd Hate Crimes Act, pursuant to constitutional authority under, and this would be the critical part of this analysis, the 13th Amendment. The relevant law authorizes federal prosecution of whoever willfully causes bodily injury to any person or attempts to cause bodily injury to another person because of the actual or perceived race, color, religion, or national origin of any person. In enacting the law, Congress found that slavery and involuntary servitude were enforced both prior to and after the adoption of the 13th Amendment through widespread public and private violence directed at persons because of race, color, ancestry, or perceived race, color, and ancestry, and eliminating racially motivated violence is an important means of eliminating, to the highest extent possible, badges, incidents, and relics of slavery and involuntary servitude. This is very interesting grounds on which for Congress to pass a law, because the 13th Amendment is the only one that prohibits private action. The First Amendment only applies to the government. The Second Amendment only applies to the government. The 14th Amendment only applies to the government. Every other amendment only applies to the government. The Constitution only applies to the government. But the 13th Amendment, by its own terms, prohibits private action. It's the only provision of the Constitution that prohibits private action. If Congress can pass a law under the 13th Amendment as a basis, that prohibits private persons from engaging in slavery or involuntary servitude, or, critically, imposing badges related to slavery. We're going to read a little bit more about this and how that comes into play in this Hate Crime Act. Counts 1 through 12 of the indictment charge Ruth with violations of the Matthew Shepard Act. He moves to dismiss them, arguing that the law is unconstitutional because it's not appropriate legislation to enforce through the 13th Amendment. He argues the statute does not meet the Supreme Court test for limiting congressional action under 13th, 14th, and 15th Amendments. In particular, he says those amendments authorize legislation only if it meets a congruence and proportionality test. Ratified during Reconstruction era after the Civil War, the 13th Amendment provides that neither slavery nor involuntary servitude shall exist within the United States. This profoundly important constitutional provision was intended to abolish slavery of whatever name, so putting a different label on it, not so much, and form, and all of its badges and incidents, to render impossible any state of bondage, to make labor free by prohibiting that control by which personal service of one man is disposed of or coerced to another's benefit, which is the essence of involuntary servitude. After striking down multiple pieces of civil rights legislation under a restrictive interpretation of Section 2, the Supreme Court in 1968 adopted a more generous approach, giving Congress relatively wide latitude to determine what qualifies as a badge or incident of slavery and how to legislate against it. Specifically in Jones, a 1968 Supreme Court case, the Supreme Court held the 13th Amendment empowers Congress to prohibit racial discrimination in private or public sale of rental or real estate. The court held that the section gave Congress not only authority to abolish slavery, but also the power to pass all laws necessary for proper and for abolishing all badges and incidents of slavery. It went on to reason that legislation at issue was an appropriate exercise of authority, that was, it was rational legislation aimed at eliminating badges and instances of slavery, because whatever else they might have encompassed, badges and instances of slavery burdened and disabled, including rights upon property. This is an interesting analysis from the 1968 Supreme Court, and you could think about it a whole bunch of different ways, but it's law one way or another, so there's that. But yeah, in 1968, the Supreme Court says, okay, what might be badges and incidents of slavery? Badges and incidents of slavery would include any limitation or any sort of disability imposed by law that would have come from slavery. What kind of limitations were on slaves would be another way of limiting this, or what kind of marks would be against them. So what limitations in law, anything that category belongs to. So the Supreme Court in 1968 says slavery, one of the things slaves couldn't really do that much was own property. Couldn't buy a lot of land. Couldn't rent. That wasn't really an option, really, for the slaves so much, was the renting and ownership of land. So fast forward to 1968, Congress passes a law saying, okay, we're going to prohibit discrimination on race in rental agreements because that's a badge and incident of slavery, not being able to own land. In light of the case law, it's abundantly clear that the Matthew Shepard Act is appropriate legislation. To prove otherwise, Ruth would need to show Congress acted irrationally in deeming racially motivated violence to be a badge or incident of slavery, but over a century of sad history puts the lie to any such effort. There's definitely something there. Congress had ample grounds for finding slavery and involuntary servitude were enforced through widespread public and private violence directed at persons because of race, color, and ancestry. And the 13th Amendment does prohibit private action. Congress also concluded that eliminating racially motivated violence is important means of eliminating, to the extent possible, badges, incidents, and relics of slavery and involuntary servitude. Those findings have been universally accepted by courts analyzing hate crime legislation. So that brings us to the end of the discussion of United States of America versus Dylann Roof. In this case, we learned that Dylann Roof was a horrible monster. He was warmly accepted into a church in Charleston, and for 45 minutes engaged in prayer and Bible reading and song, and was warmly accepted, and then decided to pull out a firearm and kill a whole bunch of people. And he doesn't want anyone to think that it's because of mental issues. So, fair enough. We don't think it's because of mental issues. We think it's because you're evil. All right, we're there. He appeals. He says, I shouldn't be allowed to represent myself. The law is pretty clear. You want to represent yourself so that the evidence of you being mentally ill can't be offered. Okay, well, that's an option. But you got exactly what you bargained for, so yay. He also argues the law is unconstitutional because it's not proper. And the court says, no, it's proper. There seems to be some racial-based animus here, and we think Congress can ban the racial animus under the 13th Amendment. And then, of course, there was, I don't even know how many, like 23 different other grounds of appeal that all got denied. So, yeah, not so much for you. So we'll see what happens in the future. I would be slightly remiss if I didn't point out that there is currently a moratorium on federal executions. This is a federal case. And Biden has, at least in the past, expressed a desire to get rid of the federal death penalty. So whether or not any of that will come to pass with respect to Dylann Roof, who knows? But one way or another, he's either dying or serving the rest of his life in some cold cell either way. So either way, I'm happy. If we execute him, that works for me. And if we make him just mark off the days until he eventually dies cold, forgotten in a cell somewhere, I can live with that too. And until either of those days comes, that brings us to the end of the consideration of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.